Navigating employee complaints, best practices for preventing future litigation. And our guest speaker today is Jeremy Snyder. Just a little bit overview on the agenda today. We'll have brief introductions about who we are, Griffin Consulting. Then we'll jump right in and have Jeremy present his topic, and then open the floor for Q&A at the end. A little background on myself. I'm the president and CEO of Griffin Consulting. I've got over 30 years of experience in the IT field. I like to say now that I started when I was 5 years old. I keep getting younger every year. I'm also the co-founder and the chairman of the board for a nonprofit called the Black Channel Partner Alliance that we created in the wake of all the social unrest back in 2020. And actually, Microsoft has been our largest benefactor to date. So that's been an amazing experience, helping Black-owned tech companies really accelerate their growth through adopting Microsoft technologies. And also serve on the board of advisors for Women in Cloud, an organization that is, unapologetic about helping women get opportunities with enterprise clients as well. And then with me behind the scenes is Luis. He's my chief officer. He's behind the scenes. He'll be managing the chat, and anyone has any questions, helping to respond to any tech issues on the back end. In terms of our background, I started the company back in 2004. We're actually based here in the DC metro area, and we focus on supporting nonprofits and professional services organizations. In terms of our key partnerships, as I mentioned, one of them being the BCPA, the International Association of Microsoft Channel Partners, and then some other distributors. And where that comes into play for our clients is if there's a technical issue that they're dealing with that we don't necessarily have the expertise in-house, I could reach back into these networks of over 2,000 partners and bring the right resources to bear to get the problem solved. In terms of capabilities, we're what's called a managed service provider, so outsourced IT. We're also a hardware vendor as well. We focus on SharePoint deployments, all of the Microsoft stack, Dynamics CRM, and obviously voice enabling teams as well. Here I've got some of our nonprofit clients that we've been very, very fortunate to call clients. As a matter of fact, got to see a great piece yesterday on the Today Show on the Universal Hip Hop Museum. Just an amazing project there in the Bronx, really celebrating the history of hip hop music and its impact on the culture. So Trayvon Martin Foundation and Our Kids Read here locally. Today we've got a special offer for anyone on the call, for those nonprofits that are on the call that maybe haven't or are looking to take advantage of the Microsoft Technology Grant. We'll provide free email migrations for up to 10 users. Also provide you some free licenses for our Teams-based training platform, and we'll also perform a free data security assessment for you. So without further delay, I want to get us right to our content. And to be honest, I can't thank Jeremy enough for him joining us today. I actually met Jeremy almost 2 years ago now through my participation in a local provisors group that Jeremy leads. And it's really been a great experience. And Jeremy is an amazing leader and networker, extraordinaire, really. On the professional side, Jeremy, basically supports employers when they're having trouble with their employees. He helps his clients manage workplace risk and reduce legal costs by preventing and resolving employee disputes. And, unfortunately, if there's litigation, if litigation is unavoidable, Jeremy vigorously defends employers in state and federal court, arbitrations, and before administrative agencies. I don't hold this against Jeremy. He's a New Jersey native, but he's been here in the DC area since undergrad. He lives in Leesburg with his wife and their 3 children. Jeremy is also a graduate of George Washington University Law School. We're also fellow alums, love him for that. And outside of his family in the law, Jeremy enjoys playing chess, reading science fiction, and rewatching The Office on a continual loop. So without further delay, I'm going to turn it over to Jeremy Snyder.
Thank you, Frank. That's a great introduction. I really appreciate it. I'm really happy to be here today. I'm going to pull up my slides. We've got a really great topic, one that I actually really care about quite a bit. Like Frank mentioned, I try really hard to help my clients avoid litigation. Sometimes clients feel like talking to a lawyer is by itself inviting trouble. And oftentimes I try to help my clients get through a difficult issue so that they can manage it in the right way so that later um, litigation either doesn't happen at all, or we have a really good defense and we have the documentation that we need to prove our case if it gets to that point. And conducting internal investigations is one of the most important tools in a company's um, in tool chest about how do you take steps to avoid litigation. And so sort of the purpose of today is to help you understand how best to investigate employee complaints, and then to give you some kind of practical tips both along the way when you're conducting these investigations, and then sort of at the end, what are the things that you can and should do in order to get out in front of an issue that could come up in the future. And so I am gonna start off here. Frank gave me such a good introduction. We're gonna skip right through my bio. I want to tell you a little bit about Jackson Lewis. Our firm is a labor and employment firm. We only do workplace law. So if you have any issues with your employees, our firm is here to help. We only represent management. We don't represent individual employees. And we help clients navigate the sort of very complicated framework of state, local, and federal law having to do with your employees. We have a lot of offices all over the country, a lot of really dedicated professionals to this area of the law. I am the office litigation manager for the DC region office, and so our office services the DMV. But we work with clients who have people who are all over the country. And now in today's world where everyone now has remote employees who are working outside of the normal confines of your workplace, having access to that network of folks who have expertise all over the country is even more important. You'll get a copy of this at the end, but here are some of our practice areas. We're talking about general employment issues, wage and hour, corporate diversity, corporate and governance, and internal investigations. That's a practice group that I'm a member of. Employee benefits, healthcare, international employment issues if you have employees who work overseas, traditional labor issues if you have a union in your workplace or you have employees who are thinking about forming a union. We also deal with workplace safety, OSHA, if there happens to be issues about safety in the workplace, and privacy and data insecurity and some of these other things as well. So this is what we're going to go through today. What do employees typically complain about? Why would you conduct an internal investigation? How do you take the complaint in? How do you prepare for an investigation? What do you do when you're interviewing witnesses? How do you memorialize your findings? And how do you make recommendations? And then we're going to talk about the best practices sort of at the end as kind of a way to sum it all up. What do employees complain about? Everything, right? I mean, I'm joking, but I'm not. Employees will complain about really anything that bothers them in the workplace, some of which is actionable under the law or illegal, but most of which is not. And so what you'll often find is you'll have an employee who's complaining to you about EEO issues, discrimination or harassment or hostile work environment. You'll have employees who have medical conditions, health issues that are ongoing, or they're asking for an accommodation to their position. You know, in the last couple of years, the most often sought accommodation is continued telework, and all of the issues that present itself with that. Employees also complain about their wages. They'll often ask questions about their specific paycheck. If they're eligible for overtime, they may ask questions about whether or not they were paid properly. They also complain about their working conditions. Do they think that the workplace itself is safe or unsafe? This was a big deal, as some of you I know will know during the pandemic. Is the workplace safe? They'll also complain about other unlawful conduct, sometimes especially in the context of nonprofits who we're dealing with here, or many of you are. Talking about fraud, waste, abuse, mismanagement of donor funds is an issue that comes up quite frequently for nonprofit entities, and especially nonprofit leaders, when you have a duty to your organization to safeguard donated funds. Employees also complain about things that aren't technically illegal, but also cause workplace issues like bullying, mistreatment, unprofessionalism. This is your classic, my boss is a jerk type complaint, which may not be unlawful under the law, but is concerning. It impacts employee relations and impacts morale in your workplace. And of course, you don't want people to be unprofessional, especially your supervisors. We've been seeing a lot recently, employees complaining about lack of diversity, privilege, white supremacy issues. Recently helped a nonprofit client deal with 2 complaints received by the same employee having to do with perceived white supremacy in the workplace. There was no white supremacy in the workplace, but they wanted to investigate into those issues. It's not as cut and dry, the idea of white supremacy, as it used to be. There's a lot more things that employees raise in today's world that they wouldn't have raised 10, 15 years ago, even that implicate the need to conduct an internal investigation. Employees also complain about board members. And if you're all nonprofit leaders, you know that board members' conduct often can be both troublesome and difficult to deal with. And there's not exactly always a clear solution about what you should do, because board members are not employees, but they're also in a position of authority in the organization. And so how do you handle those issues? Why would you conduct an internal investigation? So there's sort of both practical and legal reasons why you would conduct an internal investigation when you receive an employee complaint. Of course, we're all conscientious employers. We want to have a fair administration of your policies. You have a handbook, an employee handbook, for a reason. And although many of the policies in there may not be legally required, that handbook provides a framework under which your employees expect to be able to come to work every day. And you want to make sure that you are administering those policies even-handedly, appropriately, and that you're dealing with issues under the rubric of your handbook. If you have contracts, a lot of NGOs will have contracts. They receive aid from various organizations, and then there are contracts that come along with that. And so you want to make sure you're having compliance with your contractual requirements. Sort of at its baseline, an investigation is really about understanding the facts. I always say to clients when they call asking about an investigation and how do they do it, it sort of dates me, although I'm not so old that I watched this television show when it was on TV, but it always makes me think of Dragnet, when they would say, just the facts, ma'am, right? And that is something that you really want to focus on when you're conducting an internal investigation. You want to really have a full and objective understanding of the facts that are at issue. You want to address and stop problems before they escalate. That's what we're really here talking about. An employee complains, and this issue could spiral out of control. And so how do you contain it? How do you investigate it? And how do you address it so that you're not in a position where 6 months from now you have an EEOC charge, or 6 months from now you have an unfair labor practice complaint? And then, of course, to continuously improve. You want to be an organization that takes care of its employees. You want to be an organization that addresses employee concerns. And you want to be an organization where your employees feel like they can comfortably come to you to complain about whatever issues. Another thing that I tell clients when they call about investigations is, and this might seem sort of counterintuitive, but is that you should be at a baseline, regardless of the allegations and whether or not they are not true or they're unprofessional or et cetera. Regardless, you should feel good about the fact that an employee felt comfortable enough to raise the issue with you. There are a lot of workplaces where employees feel that no matter what, if they complain about anything, they're going to be retaliated against, and they're going to face some sort of reprisal for that. Excuse me, I'm going to take a drink. And so the mere fact that you've gotten a complaint suggests that You've created a workplace where complaints are received, appropriately. Again, though, it does seem counterintuitive to encourage your employees to bring issues to you because they, then it's an issue that you have to address. But the bigger problem is your employees don't complain, or they complain and the complaints are not addressed at all. And then it turns into something that's much more serious, much more legal, much more formalistic than it would otherwise be. Of course, there's always legal obligations. The first bullet here is something that I counsel employers on a lot. If you have an employee who complains about harassment, let's just say sexual harassment, let's go to the classic case. Employers always call, well, what should I do? And I always try to remind my clients, the first thing you need to remember is that your obligation under the law, if you receive a harassment complaint, is to investigate and take action if necessary. Now, investigate can mean a lot of different things. We're going to go through what that looks like. And take action if necessary means that you have discretion. You can choose not to take some action. If the investigation proves the allegations are unfounded, you're under no obligation to do anything if you think it's not appropriate to do so. It also means that you have sort of the full scale of remedies available for you, meaning you can either, if the complaint, sort of one little aspect of it was substantiated, you might issue a supervisor or another employee a written warning or verbal counseling, or send them for training. Not every complaint necessitates termination. Not every complaint necessitates something severe that happens. You have the ability as an employer to act with some discretion, to act with some judgment, to use what you think is the most appropriate remedy at your disposal. You also want to develop a defense to claims by outside parties. And so a lot of investigation is, how do we document what we've done to meet our legal obligations so that later, if it turns into something, we're ready to defend ourselves. Of course, you want to also fulfill legal requirements and comply, and if you have a compliance program, or you have a whistleblower program, or you have kind of a formal complaint process, a hotline, you want to make sure you adhere to those requirements. This, I think, is the number one reason why we investigate employee complaints, and it's to prevent retaliation claims. So when an employee complains about unlawful discrimination or perceived unlawful discrimination or harassment in the workplace, they complain about race discrimination or age discrimination or gender discrimination or just unlawful harassment. And when an employee complains, they step into sort of a special status where they've engaged in protected activity, meaning they've complained under the law, and that they're protected, meaning they cannot be retaliated against or face some kind of reprisal for having complained. And that is, and in doing so, disciplining an employee for complaining, or firing an employee for complaining, or cutting their hours, or cutting their pay, is retaliation. Now, what are the things that an employee will rely upon in order to prove something like that? They will rely on shortness in time between the time they complained and between some adverse employment action. They'll rely on statements made by your supervisors. They will also rely on an employer's lack or refusal to investigate their complaints. And they will also allege that they faced some kind of reprisal for having to complain or having complained in various different forms. And where does this kind of shake out? When an employee complains about discrimination or harassment, they go to the Equal Employment Opportunity Commission, or a state level equivalent of that agency, and they file a charge. And on that charge, there's a bunch of boxes that they can check, which will show them the types of discrimination that they're alleging. One of those boxes is retaliation. And retaliation is by far the most checked box on the form. You could just look at fiscal year 2021, the EOC received 61,000 charges during that year. And in 56% of them, 34,000 of those charges, the employee checked the box that said retaliation. That says to me that when that employee complained, that employee believed that no one investigated their complaint. No one took any action if they thought it was necessary. No one communicated with that employee about the investigation or the results of the investigation. And in the absence of that information, the employee believes that they were retaliated against. And so investigating and addressing employee complaints steps right in that zone to prevent these types of claims. And so, and it is by far, like I said, the most prevalent box that's checked on the EOC's form. So how do you receive the complaint? It can come in a bunch of different forms. There's no magic words. An employee doesn't need to say, I am complaining about sexual harassment, right? They can come to an HR representative or their supervisor or you as a leadership, member of leadership and say, I'm having a problem with my supervisor. And that is enough to sort of trigger at least the thought, do we have a duty to investigate and take action if necessary? What steps should we take to address this? There's no such thing as confidential complaints. A lot of employees will come and say, look, I'm just looking to vent. This is off the record conversation. That is a fiction. Employers have a duty as soon as they are aware that there's alleged harassment or alleged hostile work environment that they need to look into these things. And so even though you may have an employee who believes that they're just venting, you still have an obligation. They could come anonymously. They could come by direct email. They can come just by observation. You could see something that is troubling. They come in exit interviews. Oftentimes an employee sort of unloads on their way out the door. And so what is your obligation then? This person's no longer there. You don't really have much of an obligation to them anymore, but you certainly would have an obligation to protect your other employees. These complaints also come in the form of external agencies, meaning they file a charge of discrimination, sometimes while they're still employed. Of course, external and formal complaints that could go to somebody like directly on the board, or it could go to an outside watchdog organization, or it could go to a different agency if you happen to contract with a government agency. And of course, they can put these things on social media, which we've seen in the last 5-10 years has just exploded. Employees are willing to share basically anything and everything on social media. Oftentimes they believe that that they do so with complete immunity, that they can't be punished for those things. And there are limitations to what you can do. But oftentimes, if you're aware of a social media post that talks about alleged unlawful behavior, that's enough to constitute a complaint and to trigger some obligation to look into it. Talked about off the record, or just making you aware. There really is, again, there's no actual off the record. Oh, good. And I have a question in the chat. So I should have mentioned at the beginning, if you feel like you have questions, put them in the chat. We're also going to have 10 minutes at the end for questions, but I'll look at this one. So the question is, what if the employee mentions some action about another employee that makes them uncomfortable and asks for suggestions on how to address it because they want to try to address it before HR takes actions? You have to, again, this sounds sort of like off the record complaint. There is no off the record complaint. What I normally say to clients is you take the complaint as it is. It comes to you. If it's just, the person is sort of unprofessional or something that's relatively benign, I don't like their tone, something like that, doesn't necessarily mean that you need to conduct some full-blown investigation, hire a lawyer, bring in an interview with 20 people. But if an employee comes to you with a general concern, I would handle that concern just like you would handle any other. You might counsel them about what tips that they might do to try to limit their interaction or limit the type of interaction that caused the issue in the first place. You might also just say, let's put these two people together in a room with HR. Let's talk about what's going on. Let's see if we can come to some kind of agreement about how we're going to proceed. But a lot of that is sort of evaluating what the content of the complaint is. And I always find that the best practice in that is not necessarily immediately hire a lawyer to investigate and interview a bunch of people and disrupt your workplace, but maybe give your lawyer a call and have a 10-minute conversation where you're sort of partnering with one another about how to address this issue. and come up with a plan together. And then I often say to clients, it's a step by step. We might have one or two more of these phone calls. We'll see how the first step goes. You call me back, you let me know. And then we kind of come up, we go step by step. And at the end of this, hopefully we have a resolution. And then if it needs to go more formal, or there needs to be some kind of discipline, or there needs to be some kind of action, then we talk about what that looks like together. It's the worst feeling in the world when a client calls and says, well, we have a new charge of discrimination that we have to respond to. We fired this person a couple weeks ago. And I always ask, okay, you fired this person. Did they complain about anything right before they left? Did they raise any issues with their pay, or did they raise any issues about discrimination or harassment or a medical condition? And then when a client says, well, yeah, they did, but we were planning on terminating them already, I'm always like, okay, that might be true, but if we would have chatted with each other for 10 minutes before you took action, I'm not saying I would have stopped it, or I would have told you you can't, terminate your employee. You're an employer. You're allowed to do that. But maybe we manage it in the right way, document it in the right way, so that this charge might not have happened. But anyway, that's kind of my answer on that. But I think it's an evaluation individually. You can't not act because an employee says it's not a big deal. That employees consistently will minimize what it is that they're experiencing. They will also over exaggerate what it is that they're experiencing as well. But in either situation doesn't matter for your obligations as the employer. And the other bullets here sort of speak for themselves. You may have an uncooperative victim. I'm not, it's kind of a weird term, but a person who complains that doesn't want to do anything further, you still have that obligation. They can choose not to sit down with you to chat about it. That's fine, but you're still going to have to look and come to some kind of conclusion, even in their absence. Oh, got another question. Oh no, this is the same one. So key information, how do you receive the complaint, and what is the key information to obtain? You want to find out kind of who and what the employee is reporting about. You want to know what exactly occurred, when and where did it occur? Were there any witnesses? Did anyone else experience the same treatment? Did the employee or anyone else report it to anyone? Are there relevant notes, emails, texts? Oftentimes text messages now is where the action is, for lack of a better term, and really getting in those text messages so that you can read them really helps you. And then, of course, I always like, when I'm first talking to an employee, I always recommend to clients that you should ask them, is there anything else that you think I should know? Because oftentimes that open-ended question results in kind of an outpouring of information that you wouldn't have otherwise gotten. And so don't be afraid to say, what else should I know? Or what else should I be aware of? Or what else do you think is important? Because oftentimes, another aspect of this is allowing an employee to there's a cathartic experience to complaining. And if they feel as though their complaint is being heard, it is being addressed, you're approaching them in the right way with empathy, oftentimes that de-escalates it, that takes the temperature down a couple notches, and you're more likely to not end up with a complaint later, with a formal charge or litigation later. So one thing about preparing to investigate, I mentioned this earlier, is that a big question is, what do we do? Do we have to hire, who conducts this investigation? Do we have to hire a lawyer? Is HR automatically responsible? Is a manager the responsible? If you have a compliance officer, or do we hire some outside investigator? It's not a lawyer, just an investigator. And again, like I mentioned in the previous question, this is sort of delicate. It is on a case-by-case basis. I will tell you that in most cases, when my clients call and they've received a complaint, and I'm sort of walking them through what to do next or how to respond, I often will say the best approach is for HR or a disinterested manager level employee, at least management level employee, if not executive, to conduct the investigation, that I will help them step by step kind of come up with the investigative plan, maybe help them come up with a list of interview questions. And then that way, we are working together, we're partnering together. I'm helping you get the most information you can, while at the same time, it's not me talking to your employees. And that can be bad for a couple different reasons. First, nobody likes talking to lawyers. I'm happy you all are here and you're watching me talk, but when I talk to employees, it really ratchets the stakes up. They don't want to talk to a lawyer. They're intimidated. They clam up. They don't want to actually share what they know. And that's a hindrance to the investigation. So oftentimes someone who they know and trust, who has some guidance from a lawyer, is helpful in getting you kind of the objective facts. But again, it's a step-by-step deal. We also train our clients. If you have HR representatives, we do an hour-long training, kind of just like this, where we help them, help train them on how to conduct investigations. And once they have that framework, it's often much easier for them to do it. And then, of course, there's not a concern about conflicts. I would much rather help your folks work through an investigation, and then later, if it turns into litigation, be able to defend you, than conduct the investigation myself and then be conflicted out of representing you if it turns into litigation. If I'm the one who conducts the investigation, I can't also be the one who defends that investigation in court. And so oftentimes clients find we can deliver more value by waiting for there to be litigation while also helping you get through the investigation. Objectivity is the key. I talked about attorney, what it means to be objective. We're objective. We can write an objective report. We can be factual, but there are privilege issues. There's pros and cons. We have to tell employees when we interview them that we represent the company, that we don't represent them. These are ethical obligations, that the investigation is privileged, that they can't share some information with other people, that the company is the one who controls that privilege, and that all that conversation, which happens in the first 30 seconds of an employee-led interview, usually means that the employee is sort of on their heels to begin with. Human resources a consideration, a compliance professional, sometimes a supervisor, certainly not the person. If the employee is complaining about their supervisor, that supervisor should not be the one conducting the investigation. That supervisor should be sort of separated from the process entirely. We'll talk a little bit more about what that looks like. All right, so what do you do before the investigation? You want to determine the scope. You don't need to do 30 interviews for every investigation. Who are the people who might know something? Chat with them. You want to gather the relevant policies and documents. You want to look at what emails are out there, emails, text messages. You want to make sure you have all that. You want to analyze the complaint. I often recommend, it's not required that an employee submit a written complaint, but I often recommend to, especially to HR representatives, because it helps with the investigation, that you ask the employee to put their thoughts down on paper in some form or another. It's not mandated. You shouldn't require them to do that, but you should ask them, please, it will help me to conduct this investigation if I'm able to refer to something that's in writing. I want to address this issue with you. I really want to help you, and this will help me help you. And that's usually enough to get an employee to put something down on paper. You want to look at other relevant complaints. Has this supervisor ever been complained about? Has this employee ever complained before? You want to look at your emails. Cameras sometimes are a really big deal. If you have security cameras and there's an allegation of inappropriate touching or something on the, and if you have security cameras and that might have been captured on it, that's certainly something that you'd want to look for. You want to look at personnel files, prior disciplinary history, other information that would be contained in your personnel file. You want to come up with kind of a plan for your investigation. And these are the types of things that you want in your investigation plan. You want to understand what the purpose is. You want, and that can be a summary in 2 sentences. We need to investigate this complaint and confirm whether or not what this person alleges is true. You want to understand the issues that are going to be addressed. This happened and how do we address it? You want to understand your policies and your procedures and your rules. You might have an investigation policy in your handbook. You might have a complaint policy in your handbook. You want to make sure that you're not running afoul of any of those policies. You want to have objectivity and impartiality. You don't want somebody who's the accused being directly involved in how the investigation plays out. You want to have in the end, you want to have an accurate and complete record. You want to have you want to be able to make fact-based decisions. You're not just making it based on, emotion or the kind of the sort of degree of the allegation, right? I mean, some allegations that employees make are shocking, and you don't want to react to the shocking allegations without having really the facts that you're going to rely on. And of course, confidentiality is a really big thing too. You want to make sure that you're not sharing more than is necessary with the people who you're speaking with. And we'll talk a little bit more about that as we go. You want to set some goals, full objective understanding. You want to prevent the issue from becoming an external one. That's what we're talking about here. How do you prevent litigation? Fact-based decision making, we already talked about. You want to take action and confirm. You want to really take action if you think it's necessary. Preserve all the evidence, because later a lawyer like me is going to ask you, okay, we did this investigation. Let's see a report. Let's see some notes. Let's see some interview summaries. And then you want to have an institutional record. You want your organization to have shored up all of these issues before it becomes something that's external. Now, conducting interviews is sort of an art, okay? It's not a science. There isn't, you can follow a list of questions, but it isn't always like that. It isn't always the best to just go down a list and then type up a report, right? There's something to it, right? There's something to getting information out of people. And so who are the people who you want to interview? You want to, obviously, the person who complained, and obviously the person who was accused. Typically they're last. You would like to interview them last. Witnesses. So when you're talking to people, ask, is there anyone else who you think I should talk to? Is there anyone else who you think might have saw the incident? You will want to talk to the managers and the supervisors of both people. Is there anything weird going on? Have you noticed any tension between these two people? And then anyone else whose name comes up during the course of the investigation, you're going to want to track down. Now, again, this is not meaning you need to interview all of your employees, because some of them might know one thing or another. You really need to use a little bit of discretion, because the more people that you interview, the more likely it is that sort of rumors are going to begin to swirl and that something is going to get back to somebody. And that's not a situation that you want either. You want to get as much detail as possible. You want to select an appropriate location for the interview. Sometimes it's, like in a windowless room with dim lights is not going to get you the information that you want from folks. It's not going to help you understand what's really going on. It's also going to intimidate people, and also will probably, if you did something like that for the person who's complaining, it's going to make them feel like you're not, with empathy accepting their complaint and sort of in good faith investigating it. You're going to want to ask the 5 W's: who, what, where, when, and witnesses, right? So you start with those 4 questions and all in between, and then you ask, who else do you think might know something? Or who else do you think I should talk to? You want to get facts. You don't want rumor. You don't want opinion. People are going to tell you what their opinions are. You're going to have it, right? But and you can take those into account to a certain extent. But really what you're looking for is, what is it that's tangible? What is it that I can sink my teeth into here? When you're conducting interviews, you can't promise confidentiality because it is largely impossible. Higher level folks are going to have to know about what's going on. Higher level folks are going to have to know about the investigation. Oh, and I got a question. Who was the last person interviewed? I did say the accused. Typically, it is the accused. Now, sometimes you've got the accused in front of you. There may be some extenuating circumstance, but typically what you do is you start with the accuser, and then you have folks in between, and you end with the accused. You want to take careful notes. You want to tell people when you're talking to them, this is going to be kept on a need-to-know basis, because you don't want to box yourself in. There may be some people who are going to need something. You want to limit disclosure of information by way of your questions. Here's a classic example of how and why you would want to do that. Let's say that you have an employee who complains about another employee, not a manager, but a coworker. They're complaining about sexual harassment. You should limit the disclosure of that allegation or the identity of the accused, right, to the people who you interview, because what if it gets back to the supervisor, or what if it gets back to somebody who is in authority over the accused and they take some kind of action based on that? And now you've got a retaliation claim, which is the entire point that we are trying to avoid. Oftentimes I will tell clients, let's put the accused and let's put some of the supervisors off to the side entirely. Let's not even tell them what's going on. We, in no situation, then later, if it becomes a litigation or becomes something where we have to defend it, we can say to the court, or we can say to the EEOC, we can say, look, yes, the supervisor later took some kind of action against the accuser, but it's not retaliation because no one ever informed that supervisor that there was a complaint. They didn't even know. And that's an absolute defense to retaliation. If you can show that and document that, you do not want to be in that situation. Follow-up question, do you let the accused know before interviewing, or do you wait? You know, again, this is a case-by-case situation. Oftentimes, if the allegation is severe enough, you might send both employees home to work on, to be on paid administrative leave while you're investigating it. You may, and again, sometimes the investigation is you're talking to only the accused and only the accuser in the same day within a couple hours of each other. And so there may not be the need to run out and make this kind of reveal this kind of information because you've got a shorter or truncated timeline. So again, I think it's play it by ear, but you know, I typically try not to. The accused might know, might hear something from someone, or the accuser might tell, and that's fine. But you probably would want to limit the information that you're sharing with the accused up until the point where you're talking to them. Teresa's asking, to prove retaliation, does there need to be intent? So the elements of retaliation are protected conduct, number one, adverse employment action, number two, and a causal link between the two. And so there doesn't need to be intent, specific intent, like an employer who will actually, a supervisor who actually says, I am firing you because you complained. That never happens. And the law reflects that. What the law will look at to form what, to prove whether or not there's causation is temporal proximity. If an employee complains and they're fired within a day or two, the court will look at that as, okay, that proximity in time is sort of strong circumstantial evidence that there may be retaliation. Now, there are things you can prove to rebut that, right? Sometimes the decision was already made to let somebody go before they even complained. And then I always ask, we need documentation on that, because it's nice to have an email from 2 weeks before the person complained where the supervisor is saying, this isn't working out, we're going to need to terminate her, by February 1st. And then she happens to complain about something on January 30th. But you've already made the decision, and if you follow through with it and you have documentation of that, you're in a good position. All right. Establish trust and rapport. You get the most information when they feel comfortable talking to you. Uncooperative witnesses. This often happens, especially the accused. You may have a person who just doesn't want to talk at all. First, you try to establish a rapport with them, explain the process. We need to investigate these things. I'm sorry, we're taking up your time. Not for the accused. You don't typically apologize to them, but a coworker, let's say, we really need your help. Try to make it about them helping the employer. You're really important to this. We really need to understand what's going on. That usually gets people's walls to come down a little bit. Communicate the policy. Typically, you should have a policy that requires your employees to participate in investigations if asked to, and they could face some kind of adverse employment action for refusing. And that sort of how you take it to the next level. You want to document their refusal to cooperate, and then you want to consult with other people to determine what the next steps are with that witness. Sometimes maybe it's a different person who comes in and tries to interview them again. Re-interview at the end. I like to take my notes. I spend a little bit of time looking through my notes and I say, oh, this person mentioned this one thing about this other person. Let's go back and chat with them for a couple minutes, try to figure all that out. Follow up is necessary. You want to memorialize the results. It doesn't need to be some 30-page report with a whole bunch of legalese and all that, but a memo to the file, something that documents that you've conducted this investigation, that you've come to some findings of fact, you were or were not able to corroborate the allegations, and then something that says what it is that you decided to do. That's really what establishes a really strong defense that you've met your obligation to investigate, memorializing it in writing. Doesn't have to be an email where you send all the details to the accuser. Really what it should be is a memo to the file. Gets placed in somebody's personnel file. You to determine what corrective action is necessary. We sort of talked about this before, but the issue here is you don't have to fire everyone who's accused of something, and you don't have to let them off scot-free either. You can pick an appropriate punishment if you think one is appropriate for the situation. Not every complaint requires termination, and not every complaint requires to just be get off scot-free. You also should look holistically. How did this happen and what can we do better in the future? And here's what the report looks like. Summary of the allegations, the evidence that you gathered, the findings and conclusions. Supporting documents are essential, emails, text messages, etc. And then you're going to have a file at the end that's sort of everything. Kind of a timeline of what you did, the actual complaint, witness statements or notes from their interviews, the report, any follow-up documents, and then of course you want to make sure that this record is not destroyed, that somebody keeps it safe. HR typically house it in a confidential file or within somebody's personnel file. Post-investigation, this is often a stumbling block. You don't want to discuss any of the information obtained during the investigation except on a need-to-know basis. You want to go to, if you do take some kind of action, you don't have to share with the employee who complained exactly what it is that you did, but you should follow up with them and say, hey, we investigated what your allegation, we took this action. We took some action and to remedy it. Please come to us if there's anything else that happens in the future, right? That's when you're monitoring the situation to prevent recurrence or retaliation. And then if you learn something else, you can always reopen the investigation. So here's our recap. These are all the steps. I'm not going to go through them one by one, but this is, take this PowerPoint and use it as kind of a guide. These are the things that you need to do. All right, here are our best practices. You want to obtain a written complaint. Very important. You can't, I would not recommend requiring it, but I would strongly recommend asking and sort of really laying it on thick about getting a written report. Tell the employee, it will really help me. I want to help you. I need as much detail as possible. I can also take notes and you can even offer, I'll type up what I think is a summary of our conversation and you let me know whether or not this jives with what your recollection is. That's a good, another way to kind of get someone oriented in the right direction. You want to choose the right investigator. Is it HR? Is it a supervisor? Some other executive? Outside counsel? It does happen. I do say that preferences for counsel to help you through the investigation to make sure that you're ready. But I would also say that it does happen on occasion. Sometimes there are situations that occur that counsel is absolutely necessary. And oftentimes that involves board members' conduct, high-level executive conduct. Those are the types of situations where counsel will step in and it's totally appropriate. You really want to preserve the attorney-client privilege for the investigation. You want to think about when to use an outside investigator. There are folks who do that. They're not lawyers. Sometimes they are lawyers, but for the purposes of an investigation, they're not acting as lawyers. Consider taking interim action. Oftentimes I recommend to employees, let's separate these two people. We don't know what's true or what's not, But these people cannot work together right now. They cannot be interacting with one another. And so let's change their shifts. Let's change their physical work location. Let's consider sending one or more of them home on paid administrative leave while we're conducting the investigation. So think about that. Exclude, oftentimes the people will have they're complaining, you're conducting the investigation, and you learn that they're represented by counsel. Outside plaintiffs or employees counsel, they have no right to be involved in the investigation. They will ask, they will want to be present for an interview. They will want to come down to your work site. That is inappropriate. And you are well within your right as an employer to exclude an employee's counsel from your own internal investigation. That's another area where outside counsel can help you. I've stepped in before, contacted plaintiff's counsel or employees counsel and said, look, they're doing this on their own. Great, we have 10 minutes left. Hopefully we get about 5 minutes of questions. So union considerations. There are a lot of union activity lately. Nonprofits are all over the spectrum on whether or not they deal with union activity. There are certain policy worlds where your employees may be hypersensitive to union issues or may be considering unionizing in your workplace. And so one thing that I want to make sure that everyone keeps in mind in this regard is you can't tell your employees to not talk about their work conditions with anyone. That's would violate the National Labor Relations Act, which even if you're a non-union employee or a non-union employer, you can run afoul of if you preclude your employees from talking about their working conditions. And that working conditions, the NLRB, the board that administers that law, they take a very expansive view of what that means. Always involve IT. Lots of things are in emails and text messages, etc. Go right to IT. If you use an outside vendor like Frank and his guys, go to them. We need this person's email. We need to preserve it. We need to look at emails sent or received during some date period, and they will help you preserve that information because later, if it turns into litigation, you need that. You need to be able to preserve that information. You want to think about confidentiality. Make sure that it's not people who don't need to know that learn about the facts. The rumor mill will swirl, but it shouldn't be coming from you. No retaliation. That is really the most important thing. That if the employee is complained and you're actively investigating, they should largely be treated as if no action should be taken against them in the near term. That doesn't mean that they're absolutely protected, or if they stole from you, or if they assault an employee, or they do something else that you can't take action. Of course you can. But let's be careful. Let's think about what any action would look like. You also want to make recommendations. You want to say, okay, this is the stuff that we can do to fix it in the future or stop this from happening. You also want to close the loop. You want to go back to the person who complained and you want to say to them, we looked into it. We took some action. I can't share because it's a personnel matter. I can't share exactly what that action was. But we thank you for coming to us, and we appreciate it if you let us know if anything else happens in the future. And with that, questions. I've got one in the chat. How much is a union generally privy to regarding a complaint or investigation? A union will want to be privy to as much information as possible, but you do still have the right to conduct an investigation. Employees who are also unionized, typically in the collective bargaining agreement, there's a provision in there that for any interview, workplace interview, or some kind of process that the employer is talking to an employee for, that they be allowed to have a union representative present. And so if you have a union workplace, you're going to want to go to your CBA and see what the deal is there. What does the CBA require you to do if you're going to interview an employee? And you may have to allow a union representative to be present. That doesn't necessarily mean that you have to share everything with the union. You don't. But union activity typically governed by the CBA. So that's your number one resource. Anyone else? All right, I'm going to say, I've got a couple things that I'd love to give you all. All you have to do is either email me or send me a link to connect with me on LinkedIn. I have a number of multi-state resources that the firm puts out for remote workers for all over the country. I also have desk reference guide for all the various employment laws in the DMV and other places all over the country. I love sharing these with HR folks. I love sharing them with leaders at nonprofits because it's like a nice little cheat sheet for the employment laws that are most important to you wherever your jurisdiction is. So if you send me an email or you connect with me on LinkedIn and ask for that stuff, I will send it your way. And Frank has got his special offer too. He's put it right up here.
Jeremy, I can't thank you enough. I hope everyone that joined today really got something out of this program. Jeremy, you're an amazing person, a tremendous ally, and I can't thank you enough. And then before you all leave, we are offering for anyone on the call. You see the things here. The other thing I'll add is also any nonprofits that need help with claiming or maximizing their Microsoft technology grants, please reach out. So with that, I'm going to give everybody a couple minutes back of their day. Jeremy, thank you, thank you, thank you. Luis, and I hope everyone has a great day.
Thanks, everyone.
All right.